Well, hello, everyone. This is Nina Olson, and this is the inaugural Tax Chat, which is a program of the Center for Taxpayer Rights. And we're going to try to do this on a monthly basis, give or take a few days, where we'll bring people in who are working in the field of tax administration and taxpayer rights and have conversations. And I'm really not wanting this, it's not a formal presentation in the sense of, PowerPoints or formal questions and answers. It's really a conversation and a discussion. We're going to hear from our guests at first, and then we will move on to questions and answers. And if there's something during the conversation, I've got you all muted, but during the conversation, you can put it in the chat box and I'll be watching. And if it makes sense to discuss in the context of what's going on, that's great. Otherwise, we'll leave time definitely at the end for questions and you all to join into the conversation. I apologize in advance. You may hear a cat meowing in the background. That's just what happens in my household. I can't keep her shut up. We have two wonderful guests today that are very familiar to all of you. We have Professor Pasquale Pistone, who is the academic chairman of the International Bureau of Fiscal Documentation, IBFD. And I won't go on about all of his qualifications. He's globe-trotting, except not right now, back and forth between many different places, Vienna University, Amsterdam, and Italy. And then as our other guest, we have Philip Baker, who is a barrister in Queen's Counsel and is both at the Field Court Tax Chambers in London. And he maintains, his academic credentials by continuing to teach at various places. But both Pasquale and Philip are the co-directors of the Observatory for the Protection of Taxpayer Rights. And normally the Observatory presents its reports every year at the International Conference for Taxpayer Rights. But because we've had to cancel that or postpone it till next year, and I'll talk more toward the end about the international conference, we thought this would be a good program to kick off our tax chat. And so I think just to start it off, I'm going to ask Pasquale to talk about, and why the observatory, why create it? What are you hoping to do with it? And what have you done with it, and sort of describe the format. And then we can go on to some of the things that we've seen from all the national and annual reporters. So Pasquale, you want to just start?
Yeah, thanks very much, Nina. I would like to thank you for asking us or inviting Philip and myself to do this kickoff tax chat. For us, it's a great pleasure. And I think, for us, it's really important to take this opportunity to stress once more the importance of synergies to achieve a balanced analysis of those issues which are related to the protection of taxpayers' rights around the world. Our role with the Observatory is not to advocate. We have set up a non-judgmental platform with open access, and we want to make information available to anyone in the world. That is important for tax authorities, for judges, for taxpayers, and for anyone who's interested in seeing what is happening in other parts of the world and using it in a way that can be, frankly speaking, that can be reliable information. And so somebody can rely upon what is written there. So this is something which didn't exist. And it's actually the result of a research project that started when Philip and I were invited to act as general reporter for the International Fiscal Association. Philip has been very, very active for many more years than I in the field of the protection of taxpayers' rights. But it has been a pleasure since we started this project together to create something that basically didn't exist. Now, anyone in the world can find information available in English and also processed with our annual reports. And we felt that, teaming up with you would be the right way forward. What I really like in the Center for Taxpayers' Rights is that you promote a non-confrontational dialogue between taxpayers and tax authorities. And this is really the way forward. This is where we can learn from each other. We can learn about good practices. We can learn about what has happened in some countries of the world and try to find ways around the problems. And well, this is really the spirit of the Observatory. It's handled by IBFD. It's on the IBFD tax research platform, so www.ibfd.org. We have a little section which has open access, and anyone can find this information, but the Observatory belongs to the world and the tax community. So this is really important because we have reporters and correspondents. I see actually several of them here in this tax chat. And it's really important also that we say one more thing. We identify the origin of the reporter. So whether that person works for tax authorities or taxpayers, not because we want to put a stamp or a mark on somebody, but just because we want to show also that sometimes exactly the same facts can be reported in a slightly different way. And each and every reporter has the possibility to present the arguments that are perhaps in tax authorities to have a different view from that some taxpayers. Yet, everyone has the right to present this information. And of course, this information is processed, so we make sure that it comes out in a sort of homogeneous way. And then it's made available to the world. That also avoids that people around the world just quote some cases because they are in the English language and they have no knowledge of something which is in the Chinese language or in the Russian language or in whatever other language. So this is pretty much the spirit of the Observatory, Nina.
So Philip, you started out by identifying certain key characteristics, principles basically that you wanted the reporters to sort of respond in terms of their own jurisdiction with an initial assessment, and then each year there would be an updating of whether things had improved or deteriorated, if you will, or just stayed static. So can you talk about maybe some of the principles and how they, you developed them?
As Pasquale explained, the Observatory, in a sense, grew out of the International Fiscal Association report for Basel on the practical protection of taxpayers' rights. And the process of preparing a general report, I suspect many people on this chat know this, is that a questionnaire is prepared by the general reporters, goes out to the branch reporters, and they then come back with answers. So typical question, does legal professional privilege extend to non-lawyers involved in giving tax advice there? And on the basis of that, we analyzed the replies, and we could sort of discern from that what was the current state of play, so to speak, what was sort of the minimum standard and what was the best practice. We developed some 80-odd best practices and minimum standards based upon those reports. What we've done with the Observatory is, in a sense, to continue that by asking the reporters from each of the countries, and we've got 43 countries covered now in the report that was released earlier this year, and we're always trying to add more countries. If there's anybody here who's on the call and who would like to provide the information for one of the countries that is not yet covered, or if there is a reporter, but we usually try to look for more than one reporter. We look for usually somebody from the tax administration, an academic, a practicing lawyer, because sometimes they've got a different perception of how a particular practice is or is not observed in that country. So if anybody on the call is interested, we are certainly very interested in growing the network. Anyway, so what we've done is to in a sense, take the best practices and the minimum standards that we developed for Basel, and we tried to see what's happened to those in the last couple of years. For example, has a country that previously did not observe what we regarded as, say, a minimum standard, have they now adopted it? That's an improvement. Has a country that previously had what we might have regarded as the best practice, say, change that practice, and they no longer live up to the standard they have themselves set? I emphasize very much what Pasquale said. This is non-judgmental. Right the way back when we were first discussing the report for Basel, there was a lot of concern that what we would do is we would produce a report that pointed the finger at particular tax authorities and said that tax authority is abusing taxpayers' rights in this way or another. We said that's not going to help anybody there. What we wanted to do, we realized that it's essential in every country to have a high degree of cooperation between taxpayers and the tax administration. Most taxes collected, generally 95% plus, voluntarily, well, voluntarily in inverted commas. I mean, there are legal sanctions, but without any intervention by the tax authorities. That involves an astonishing degree of cooperation from the taxpayers and their advisors. And taxpayers and advisors will not give that degree of cooperation unless they receive respect and their rights are protected, their information is regarded as confidential, they are assisted wherever possible by the tax authorities. So what we're looking for is, what it says on the tin, practical protection of taxpayers' rights. And there's a huge amount to learn from what other countries do in order to ensure that taxpayers' rights are protected. So that's the ethos, and those are the 80-odd principles, standards, whatever you want to call them, which were the starting point for the observatory.
So this year we sort of, in looking at the reports and certainly in our conversations, we've come up with a few areas that you've seen a lot of activity in and also developing activity. So I thought we could focus on those. And the first one that we were going to focus on is the right to privacy. I know that there's been lots of activity in Europe, and you start with the Berlioz case from a few years ago, and now you have the Shakira case, and I know that there's some pending cases. And this is, of course, in terms of the issue with the automatic exchange of information, between countries. So I don't know which of you wants to start to talk about this, but I think this is a topic that's very important, and it's also gotten a fair amount of coverage, some of these cases, in fact, in the United States press over the weekend. So.
Pasquale, why don't you start and I'll follow.
Yeah, with pleasure. Yes, I think it's, there is one important point here is that we understand, and I can see it really with this tax chat. There are people from all around the world, and we are essentially speaking the same language, not meaning English, but we're also speaking the same language in terms of problems that we have. But countries around the world take a different approach. Now, in Europe, the issues connected with the effectiveness of the protection of the right to privacy are picking up in the judicial practice from the Court of Justice. And I think it's quite important also to see what has happened. We have tax developments and non-tax developments. Mm-hmm. I would say that the starting point is a non-tax case, and the Schrems case, and that is connected with the protection of confidential right to privacy and related information. And that was about information surrendered to a non-EU country, in particular, that was the US. And the case law from the Court of Justice has repeated that there are some potential issues in protecting privacy at the standards of the European Union. However, the Court of Justice has had several opportunities also to apply the same principles to the tax area. And that is pretty much connected with exchange of information and mutual assistance. For a certain period of time, there was absolute certainty as to the fact that mutual assistance is just a matter for tax authorities. It's just a matter for one country being obliged to supply information to the other country, or from the moment in which automatic exchange of information picked up, making its data available to tax authorities of one or more other countries. Well, from Europe, it's now clear that there is legal standing and the affected persons or third parties holding information have the right to make sure that mutual assistance is exercised in conformity with the rule of law. So it's not that tax authorities of country A want to be more generous and give tax authorities of country B information that they were not obliged to give. Well, the issue from the Berlioz case that I think Nina mentioned a few minutes ago, the issues where, well, we need to make sure that if this information is surrendered to another state, then all is done in conformity with what is established by the rule of law. Now, the Berlioz case is interesting because it didn't say that the taxpayer has to be given access to the information that is exchanged, but the taxpayer may have the judiciary checking that this is done in conformity with the rule of law. And from this perspective, this case was about a third party holding information. And this third party, as many people perhaps know, refused to surrender this information. Refused to surrender this information, and there was a fine, there was a penalty linked to that. And in that case, you know, there was a right to a legal remedy, and in respect of this penalty, this is a starting point of the Shakira case that interested those cases. There was the opinion by Advocate General Juliane Cocotte on July the 2nd, 2020. And the case is appearing as État du Luxembourg. And there are more cases in the pipeline, as perhaps Philip may also know. Those cases are not just from Luxembourg, but also from other countries of the European Union. The difference in the Shakira case is that one of the company that was asked to produce or to provide this information was a company controlled by the taxpayer herself. And this is interesting because the issue was in the questions refer specifically to the right of privacy. So protection of the right of privacy and the right for the person to be able to prevent any possible damage from the breach of the right of privacy. Now, many people know that within the European Union, we have the General Data Protection Regulation, and that's really showing the extent to which we have a strict protection of data within the European Union. And the issue is whether information made available to tax authorities breaches this data protection. And in my view, I think that making information available to tax authorities allows tax authorities to exercise their right to have an effective audit and have all information needed for auditing. However, when there are different levels of data protection, then there is a risk that the information becomes publicly available. And this is a big issue between the EU and the US, because I'm not sure that the same level of data protection or protection of the right of privacy apply in the EU and in the US. And that is an issue of general concern, which I am quite sure that it will soon raise several questions to be referred to the Court of Justice. Now, this is bringing my part to, my part of the answer to almost to an end. So the critical issue is really understanding what may happen for the future in respect of data protection and in the framework of automatic exchange of information. But what is clear for me is that in the European Union, the ex-post approach wouldn't work with the case law from the Court of Justice. And this is also the line of reasoning that Philip and I adopted several years ago when we were sort of questioning that countries could no longer have an effective protection of the taxpayer before information is exchanged. Philip and I actually stressed in that report that the protection of taxpayers' rights is not about making damages good, about compensating damages, but it's about having an effective legal remedy that prevents the damage from happening. And now I hand it over to you, Philip.
Okay. Let me, I think, pick up one particular area of confidentiality. I might come back to say a little bit about two other areas in a moment, but the one particular area is confidentiality in connection with the automatic exchange of taxpayer information. That's been one of the huge growth areas in cooperation between tax authorities. We've seen with the OECD's Common Reporting Standard, we've seen with the US FATCA, literally millions of individuals' information involving billions of dollars of funds being exchanged between tax authorities. And there is a huge danger with that amount of information traveling that it would be hacked or lost, or that it will have consequences for taxpayers that weren't originally foreseen. Let me focus just specifically on the FATCA issue, because those of you who read either the Washington Post or the New York Times, I don't know whether reading one or the other indicates which side you're more or less likely to vote in November, but you'll have seen that there was reporting in there about FATCA and about some of the case challenges. FATCA cannot, I think, be held up as a wonderful example of a country acting sensibly to protect taxpayers' rights. When it was originally introduced in the US, it was known that the costs of implementing it imposed upon financial institutions and their clients was grossly disproportionate to any possible result that it might positively achieve for the US. And of course, it is a unilateral system that works only one way for information coming into the US, whereas nearly every other system for automatic exchange works bilaterally. So, one might ask, why on earth didn't the world jump up and down and say, no, this is a ridiculous measure to introduce? Well, one of the consequences of this ridiculous measure, and I'm happy to say it is ridiculous, is that it imposes on so-called accidental Americans, those who happen to have US citizenship, but who are living abroad and may have lived abroad for the vast majority of their lives, it imposes upon them some astonishing consequences in terms of the costs of compliance, very often simply to show that they have zero US liability, but unless they meet the costs of compliance or they give up their US citizenship, then very often financial institutions in the rest of the world will not provide services to these people. And incidentally, one of the things that the articles over the weekend picked up is the quite substantial increase in the number of US citizens giving up their citizenship over the last couple of years since FATCA came into place there. And that seems to be related very much to FATCA, not necessarily just to the incumbent of the White House. It's an interesting thing that people are giving up their US citizenship to get out of the coverage of FATCA. Well, it's not too surprising that litigation is underway in more than one country outside the US on the part of accidental Americans to challenge this. There's a case that's been proceeding in the US, in France, not terribly successfully. There is a challenge to exchange of information coming up through Austria, and there's a case from the UK, sometimes referred to as Jenny's case. Jenny is a dual UK-US citizen. She was born in the US, but hasn't lived there, I think, for the last 20 plus years of her life. She was totally unaware of the obligations to file US tax returns until her bank told her that unless she confirmed her compliance, they were closing down her accounts and would no longer act for her to provide banking services. Well, she's been trying to get some form of remedy in Europe based upon the General Data Protection Regulation or her rights as at the moment, an EU citizen. So clearly, at some time in the not too distant future, one of these cases is going to end up before the European Court, which is then going to have to review whether or not exchange of information under FATCA is compatible with EU law or not. Yeah. So let me stop there on automatic exchange. I'll come back perhaps on some of the other forms of confidentiality if Nina wants to take the conversation that way.
Yeah, well, I also think you had mentioned that in the past, you know, some of the countries would give the taxpayers some sort of notice that information was going to be exchanged. That had been, looking at it from the United States perspective, when I was the National Taxpayer Advocate, I recommended, because I was concerned the IRS was actually entering into intergovernmental agreements to, I'm trying to unmute Pasquale, he somehow got muted. That they entered into intergovernmental agreements where they knew that there was some risk that data might not be as secure as it would be in the United States. And I felt at that point that, first of all, whenever you went into one of those agreements, you had to give the public notice, general notice, saying, we are considering this agreement, and here are the risks, and that would give people the opportunity to come in and say, wait a minute, I live in this country, I know the security in this country, I'm very concerned about that. Second, that if the United States entered into an agreement, they decided that the importance of getting that data outweighed the risk, there was still risk, then taxpayers whose information was going to be shared with that country needed to be given a specific notice that that information was going out. Now, nothing's happened on that, but you had mentioned that there had been times where countries, it was the norm for them, if they were going to, provide another country information, that they would give people notice of that.
Well, shall I pick that one up? Pasquale was
discussing
in particular cases concerning the exchange of information on request, where there's a request that goes from, let's say, Spain to Luxembourg, and historically, many European countries had systems that required the taxpayer or it was usually the taxpayer to be notified that there was a request for information. The taxpayer could then challenge it. In a number of countries, Switzerland, Luxembourg, the Netherlands, Portugal, they've dropped those protections under pressure from the OECD. And we regard that as a very much a retrograde step there. In terms of automatic exchange, that's huge numbers of individuals' information being sent automatically. It's very clear from the European perspective that that involves the processing of data, the transmission of data to a third country is processing. And the data subject, that is the person whose data is being sent, has a right to be notified before there is any processing of that person's data. Now, in many situations, that simply is not done, or the way that it's done is that when the individual opens up their bank account, right at the very beginning, one of the terms of the bank account will be, we will comply with the law if necessary to supply information to a tax authority for onward exchange. That, to my mind, is not compliance with the data protection regulation. And that's likely to be one of the significant issues when this matter eventually comes to litigation, is whether automatically exchanging without notifying the data subject. If you don't notify the data subject has no way of challenging the correctness of the information, challenging that it relates to them. The law requires notification, and as far as I can see, there is no reason to exempt tax authorities from that general requirement.
Yeah, Nina, let me add a couple of points to that. And I think when during our analysis of those issues, Philip and I have noted that currently still, when we have automatic exchange of information, that is not done in the so-called real time, but it's done at predetermined dates of the year, moments of the year. So if somebody's thinking, how can you allow taxpayers to object the transfer of data if that takes place simultaneously? No, there would be a possibility. So it's still possible, even if there is automatic exchange of information, it is still possible to allow taxpayers to object that. One of the intriguing developments may be when a treaty, when I say treaty, I mean a tax treaty, includes a clause that says, well, we reserve the right not to exchange information with this country in specific situations. And for instance, I can think about, I was looking on the IBFD tax research platform and found the Germany-Tunisia treaty, and that includes that type of clause. Now, that is a clause included in a treaty by a state. Can the taxpayers raise an issue in connection with that? Nina, as you know, because you're also involved in that, we are doing research also in the framework of the International Law Association. It's a project that we're doing with Juliane Kokot in her scientific capacity. And there we are also stressing the importance to consider that under public international law, there are the so-called right. Yeah, let me just repeat. Non-state actors under public international law. In the international tax community, we think that treaties are just about how two states or more states divide sovereignty, or exercise their sovereignty. But the results from the analysis of public international law show that there are rights of non-state actors. And non-state actors include taxpayers. Now, in the German language, we have recently published an article which has appeared in Steuer und Wirtschaft, number 3, 2020, so the one that was released in August, and soon there will be additional releases in additional languages. But this is also to show that if a state acknowledges that there is a risk of protection of rights or data leakage, whatever you want to call it, then there may be the possibility also to develop an ex-ante protection for taxpayers. And I think, this is an intriguing development, both in the area of exchange of information upon request and automatic exchange of information. Back to you, Nina.
Can I pick up just one little point there? And this is a positive development that's highlighted in the Observatory report, and that is a growing number of countries are putting in their tax treaties specific requirements that have to be met before information can be exchanged. Pasquale mentioned Germany, who's been an advocate of this, but I note from the reports this year that Croatia, Peru, and Sweden, quite an interesting range of countries, they've all put provisions into their tax treaties, adding particular requirements before information can be exchanged.
Good. Okay. I think the second, I don't see any questions coming in on the chat. The second topic we were going to talk about was the issue of mandatory disclosure. And it's sort of, it's a sort of, in a way, the other side of the coin of automatic, exchange of information. This is putting the burden on the taxpayer or the taxpayer's advisors to disclose information. And I'm just wondering what you're seeing and what the interaction is with the attorney-client privilege, and is this really indirectly a way of, and maybe not so indirectly, getting people to report everything and anything? So I don't know whether Pasquale.
Shall I start, Philip, and then you follow up?
Yep.
Yes, I mean, that's one more source of concern. And I want to take this opportunity also to say, I'm not just defending taxpayers' rights. I believe in the rule of law. And so certainly we must make sure that tax authorities operate in an environment which gives them access to what is required in order to have a proper tax audit. However, if you look at the European current situation, the so-called DAC 6, Directive on Administrative Cooperation, as including this Sixth Amendment, there you see that there is a framework that creates, to some extent, two problems. One is it puts the client-attorney privilege in danger, and second, it creates legal uncertainty. Let me explain why I am a bit worried about this. Well, as for the client-attorney privilege, European directives have to be fully implemented because they are addressed at states, but nothing prevents states from doing what I normally call over-implementation. So going beyond what they are required to do in order to make sure that European Union law applies on their territory. Well, from this perspective, the issue with over-implementation is that in some countries, the carve-out for client-attorney privilege does not operate in respect of the so-called tax advisors. I'm using a sort of general, label for saying somebody who's not necessarily an attorney, but it's still involved in the confidential information related to the taxpayer. And it can be that client-attorney privilege information is therefore caught in the net of the tax advisor because the tax advisor has been aware of this situation. So in this case, that information is at risk because we're not really sure that there will be an effective protection. And the second point that I mentioned before, and then I will hand over to Philip, the second now, million, but a very high number of general and specific hallmarks, and that there is a situation in which some people who are involved or are aware of some information that may be reportable, or they are aware of a tiny bit of that information and not of the overall information, and that can generate a situation which makes it also harder for the taxpayer to exercise an effective protection. In Europe, it is now clear that the protection of taxpayers' rights as fundamental rights applies not only in the judicial phase of procedures, but also throughout what I call the administrative phase of procedures. With ETLP, we've been addressing this in the Congress last year in Madrid. And ETLP is the European Association of Tax Law Professors. And the Glencore case reported in the Observatory of Taxpayers' Rights, Glencore case, it actually confirms this trend. Well, I see that it's just very difficult to have an effective protection for somebody who is simply accused of being, of being involved in a reportable scheme, in a scheme that may potentially give rise to tax avoidance. And, this is something that in my view doesn't go in the right direction. The right direction is a system of checks and balances. And frankly speaking, also flooding tax authorities with information, which is, not comprehensive, is perhaps not the most efficient way of securing a successful, handling of tax audits. So I'm quite concerned with this, but of course, Philip knows much more than me on this because mandatory disclosure comes from the UK, and it's a nice legacy that we have been left with in the EU from the UK. Maybe it will work, so it will be some nice memories from our friends from the UK, but I'm not sure as to whether this doesn't create also problems in the UK. But Philip.
Yeah, thank you for reminding us of that, Pasquale. The UK has given many things to the world that are not necessarily very desirable, and I think this may be one of those areas where perhaps we introduce something that it's going to have an unfortunate consequence. I mean, we introduced in 2003 something that we call Dotas, which is the disclosure of tax avoidance schemes, it was supposed to be growing out of the US system of registering tax shelters, but it was really a system all of its own for early information to tax authorities about particular aggressive tax planning arrangements. I think it's a very good example of this important point to ensure that the greater powers to tax authorities are balanced by greater protection for taxpayers. Making taxpayers' advisors disclose their planning arrangements, that's no doubt been very helpful to give tax authorities an early warning and allow them to pick up loopholes and to deal with tax arrangements before they have a significant financial impact on the country. And I'm not in any way challenging that tax authorities can't ask for that power, but the important thing is to balance that against protection for taxpayers. And one of the elements of the protection is that taxpayers should be able to consult with advisors, and I use that word generally, so it's not just legally qualified advisors, in circumstances where they can have a confidential discussion without the advisor saying, well, by the way, I'm going to have to report the results of this conversation to the tax authority in a matter of days because this involves a disclosable arrangement. And that's the question of balance, which then leads into this issue of how far you protect the client, what you call in the US, the client-attorney relationship or legal professional privilege, and how far you extend it to advisors other than just to lawyers. The workaround that was developed in the UK was not, I think, a very principled one. When Dotas was under discussion in the UK, the Law Society, the organization of solicitors, I'm a barrister, I'm not a solicitor, so I don't have to stand up for the Law Society. The Law Society expressed concern that some of the advisors would be lawyers and they would have to make a report about the advice they'd given to their client. And there was no other area of law where legal advisors would have to make a report like that. So the workaround that was developed was that if there was a lawyer providing the advice, then the obligation to make the report transferred to the taxpayer. and the taxpayer had to make the report, or the non-lawyer involved. To my mind, that's not a way of ensuring protection of the confidential relationship. It's just a way of sidestepping it. And it was essentially to make certain that solicitors didn't have to break their professional obligations by making a disclosure. I think that there are ways in which you can have disclosure of avoidance schemes without interfering with the confidentiality of relationships there. But perhaps I'll leave it there at this point.
You know, there's a case coming up in the United States Supreme Court, CIC Services, Inc., and it will be in this October term that involves, there are a whole bunch of issues in there, but it involves, you know, a requirement to disclose, and the entity is trying to challenge it before the actual act of disclosure. And in the United States, there is a law called the Anti-Injunction Act that basically says that the courts do not have jurisdiction. The government is not waiving sovereign immunity for anything that is trying to restrain the assessment and collection of tax. And that has generally led for, you know, a century or more to an understanding that, you know, you have to wait until the tax has been assessed or is being collected, and then you can get your day in court. And this case is squarely saying this is actually a collection of information. And it is not the same thing. It's before the assessment of tax. It's before the collection of tax. And therefore, the government, you know, that should be subject to challenges under the Administrative Procedure Act and things like that before the actual disclosure has to happen. So it will be very interesting to see what the United States Supreme Court has done. The center has filed an amicus brief in that case. So we'll see. But this is definitely an issue that's important on the United States side as well.
And I think it would be definitely very nice if somehow somebody at the court would have the opportunity to see that this is potentially creating a serious breach in the protection of fundamental rights.
Yeah.
So I hope that this would be, you know, an opportunity for the observatory to play its role. You know, open access, maybe somebody comes across it and sees that this would be seriously problematic,
Right.
From the perspective of minimum standards of protection of fundamental rights.
Right.
And this also raises the issue connected with sanctions and penalties. I would say that if there is a penalty, there must be a remedy. You know, it's difficult to swallow, if I can use this expression, that, you know, you don't have a legal remedy before you are exposed to the obligation of paying a penalty. And you know, I think this also affects the importance of proportionality in the reaction to possible infringements of the law, and also when it's not clear whether there is an infringement.
Yeah, that was the third issue that we were going to talk about. The
Perfect.
approach of, it was a beautiful segue, Pasquale. You know, the approach of are penalties to be deterrent, or are they to, in the United States, in the Internal Revenue Service's Internal Revenue Manual, they have a policy statement about penalties that talks about them as promoting voluntary compliance. So are they to, is that the way that you approach them, or is it that they are basically to be almost criminal in their sanctions, you know, fines? And then the second issue is proportionality. And, you know, we did see partly driven in the United States by, you know, what were perceived abuses in shelters, you know, some fairly strong strict liability penalties. We're seeing an increase in them, you know, where there's not a sense of proportionality. If X happens, this is the penalty, and it's often very disproportionate to the actual underlying tax. I don't know if anyone wants to weigh in on that.
Happy to do so, unless Philip wants to go first, or?
No, I'll leave it to you, Pasquale.
Well,
you're the penalty person.
Well, Nina, this issue with penalties is quite complicated in Europe, and I'm sorry if I'm again referring to the European experience, because the one issue is whether a disproportionate sanction should apply and is more effective than finding alternative approaches to secure compliance with the law. And the other thing is also that we talk about penalties, sanctions, criminal sanctions. Sometimes it's rather unclear where the dividing line between the two is. When we talk about criminal sanctions, it must be clear that there has to be real evidence of the subjective element. And some countries, what they're doing is, well, we just apply a penalty and then, you know, we put the top up tax and we add something on top of the tax that is due, and then we call it penalty and we don't care about the fact that, you know, this is not a criminal sanction. Well, at the end of the day, this is problematic because we need to understand if there has been a violation and if this violation is pretty much reflecting the subjective element of the willing to violate the law. And this is also an element that can be bundled together with the deterrent function. The deterrent function is clearly clashing with proportionality. So if we have a deterrent function, the sanction goes beyond what it's needed. So, you know, in a way, this is also something which could be questioned and also, you know, should not be the way to lead people towards compliance with tax. And certainly, if we have a serious case of tax fraud, that should be punished severely. But if we don't have a serious case of tax fraud and we still have a violation, then there should be a penalty, should be effective, but not deterrent.
Okay.
Can I follow that with maybe a segue into a slightly different issue? It's something that we have covered to quite an extent in the recently published report for the Observatory for this year. And that's this issue of double jeopardy, or if you like the Latin, ne bis in idem, where we've had some interesting developments in Europe, but at two judicial levels, both at the European Court of Human Rights and at the European Court of Justice. And I'll make a little plug here. The Observatory has a section in the report on recent cases from the European Court of Human Rights and recent cases from the European Court of Justice, which is tremendously helpful because I don't think anybody else is particularly watching those courts and looking for case law from this area. But the issue here is that tax is one of those relatively rare areas where the same conduct may end up producing 3 or maybe 4 adverse consequences for the party involved with the conduct. Someone who, let's say, engages in fraud and leaves an item out of their tax return may find that they are required to pay the tax, plus interest, plus a penalty, plus a criminal prosecution as well. And they may end up going to prison. And this is an issue that's been testing the jurisprudence of the European Court of Human Rights on the question of whether there is particularly a double jeopardy, a double punishment, where you have both the administrative fine, which may be substantial, and the criminal prosecution as well. And there was a leading decision of the European Court of Human Rights a couple of years ago called A and B versus Norway, one of the easiest cases to remember. But the issue subsequently has been whether the European Court of Justice, which is part of the European Union, thinks that the Norway case is correctly decided or not. Now, that's a very interesting issue as to how you coordinate different systems of sanctions in a way that it doesn't put an excessive and disproportionate burden on the taxpayer, but on the other hand ensures that there is an appropriate response to the particular conduct concerned. And this is something where the report, I think, is very useful for anybody who's studying that, whichever country they're in, Europe or not in Europe.
You know, in the United States, one of the ongoing issues that you have when someone has been both civilly and, you know, has a civil tax assessment against them, and then also has been criminally prosecuted, and then has sanctions from the criminal prosecution where you have to do restitution, which actually includes the amount of tax that was assessed. And there you have two different entities. You have the bookkeeping from the Internal Revenue Service, and yet restitution is worked through the Department of Justice that does the criminal prosecutions. And when I was National Taxpayer Advocate, we would get these cases where it was just unclear whether the debt had actually been paid off, because the taxpayer was paying restitution in, but it was not getting, and it was getting into the treasury, but it was not getting credited on the taxpayer's account. And so again, you had enforcement action being taken against the taxpayer on the IRS side, even if the debt had been paid through restitution, which was very problematic. And unwinding it was very difficult. And often these were people who did not have the resources at all to unwind this, you know, to figure this out.
Well, one of the things that I find puzzling about the US, and sometimes, Nina, you can explain it to me some other time, Nina, is how you can have some statutes that provide for 3 or 4 times penalties, like the RICO statute, which does get used sometimes in connection with tax fraud there. But that's a different discussion for another day.
Yeah, well, you know, I mean, even the FATCA penalty, looking at the FBAR penalty, which is, you know, X% of the highest balance in the account over the last X years. And you're thinking, but what if the account has nothing in it today? I mean, theoretically, our tax system is supposed to be based on ability to pay somewhere. And I understand the concern about going back and that, you know, you don't want to let somebody off for a past action, you know, but still you also have to deal with the present circumstances. And that also goes to the tax system applying the resources that it has appropriately. Do you go after someone that has no ability to pay in the present, or what? And that's, you know, that's a challenge that all tax agencies face.
Well, that's exactly what happened in Jenny's case. The costs of compliance just to prove that she had virtually no US tax liability, totally disproportionate to what that liability actually was. And of course, the penalties for non-compliance, either the US penalties or losing your ability to operate a bank account.
Well, I want to open this up now to questions. I know we have several reporters on the call, and so I'm going to basically unmute all, because that's easier for me than just trying to identify the people. And while I'm doing that, you know, and then if you've got noise in the background and you want to be muted, you can just personally unmute yourselves. I think it's working its way through. I can't tell. All participants are unmuted. So
you have achieved something though in doing this that people have been trying for years, and that is you've muted Pasquale.
You know, this is amazing, and it's sort of slowly working its way through. I'm not sure what's going on.
Lydia Sofrona is waving.
Can you hear me?
We can.
Yes.
Yay!
Hi, very nice to see you all. What I was thinking when I was listening to your very interesting chat was that I think an important discussion is the interplay between this new international tax governance that has been formulated through all those arrangements and the domestic front. I think an interesting discussion would be how are we to adapt the domestic tax administration governance arrangements in order to accommodate all this new environment, and how can we tailor all those demands that are imposed to administrations that have different cultures, different backgrounds, different capacities. Maybe this would be an area that someone could, I don't know, reflect upon.
You know, I think also just along those lines, I'm hoping that our next chat will be with Real Franson and Annette Agutu from South Africa, because I think that's what's happening with the developing countries and some of the expectations from them is a big issue, as well as you were pointing out about different cultures, different stages of your economy, different capacity of the tax administration or the citizens, the taxpayers, to be able to meet these requirements.
Can I just come in on that, if I may, and say that that is certainly, I think, one of the aspects that is driving the observatory is the idea of sharing best practice between tax administrations, so that a tax administration that perhaps is smaller, has less resources, but is nevertheless facing the same problem, let's say a problem of confidentiality, can see what do other tax administrations do. And one of the very significant issues is how do you protect your tax authority from being hacked by very sophisticated external hackers. Small point here, little over a year ago, June last year, the Bulgarian tax authority was hacked, and the tax information of, I believe, 6 million individuals was stolen and became available on the dark web. And some of that information included information that Bulgaria had received by automatic exchange from other countries. Well, how do you, what's the best level of protection that a tax authority can adopt? I forget which authority it was, but we identified in the observatory at least one tax authority where tax officials have two computers on their desk. One that has external links so that they can send emails. It's Japan, was it? Yes. Send external emails, communicate with taxpayers. Another separate one that accessed the internal database, and there was no electronic link between these systems at all. So there is no way, in principle, that anyone from outside, somebody else has said, hi, Philip, I think that was China, not Japan. Carlos says that. Carlos, it was Pasquale who told me it was Japan. So you can talk with your boss about this one there. Whichever country it was, it's a great way of making certain that information that taxpayers have been required to provide to the tax authority, information that they would not otherwise have provided to anyone else, is as secure as one can possibly achieve it. And the more that we can identify, as I say, best practices and minimum standards, the more we hope that it's going to be helpful to tax authorities, not simply, we're not just there just to criticize, but to actually offer sort of gold standards and, if you like, sort of silver awards. This is what you can do to try to protect your taxpayers Why do you want to protect your taxpayers? Well, in some cases, it's because it's the law. And in other cases, even if it isn't the law, it's because we want the cooperation of the taxpayers. And if we're going to ask them to cooperate, we need to respect their rights in return.
Mm. Yeah. Philip, let me add something to the point raised by Lydia. Lydia, I think that there are things that belong to the past. And one of those things is that there is some kind of superior collective interest that can go as far as completely depriving the taxpayer of an effective protection of its individual rights. Now, many countries, including your tax authorities, are going in a different direction, which is to make sure that there is an effective protection of the fundamental rights. And the Observatory gives information about what's happening and how this is being taken further around the world. But this is the future. The future is that we need to make sure that there is an effective protection of taxpayers' rights, and at the same time, that this does not clash with the right of tax authorities to do their job. And you don't have to impose measures which are disproportionate in order to achieve that. You cannot deprive taxpayers of their fundamental rights. If you deprive taxpayers of their fundamental rights, maybe somehow, somewhere, there will be a legal remedy. Think in Europe about the European Court of Human Rights, or also the European Court of Justice, and then it can change completely. But also, Nina was talking about developing countries, and I think it's also important that next tax chat will be about developing countries. Sometimes you don't have a remedy, and then you end up using a bilateral investment treaty and arbitration to the extent that it doesn't contain a tax carve-out clause. And of course, guess what? The developing country loses the case because there has been, the taxpayer has been deprived of the fundamental rights. So, the Observatory also wants to contribute, and I think that this is also the spirit of what Nina is doing, to contribute to establish, an effective protection of rights and also an effective protection of the community to the collection of taxes.
So we have another hand raised. I'm not sure I'm pronouncing this right. Tanarine Berger.
No, it's just Irene. My husband is called Tonko, and somehow, well, the computer combined the two, and I have no clue on how to just make it Irene. Anyway, Pasquale, Philip, you do impressive work, and well, we discussed privacy issues, of course, many times. I would like to address equality issue. What about equality when huge quantities of information are collected, are transferred to tax administrations? How on earth can they, secure that people are treated equally? I wonder whether you have any ideas about that. Just to give an example, I spoke one time to a tax administrator in the south of the Netherlands, and he said, oh, again, more information. I don't want more information because I can't handle it.
I think, giving too much information is as bad as giving too little, and that's the one thing. I think we should also consider, Irene, that there are techniques for analyzing the big data. Let me start by saying having too much information is as bad as having too little. However, there are techniques for analyzing this information in a way that is principled and makes sense. I'm not necessarily referring to tax profiling, but also trying to avoid that you make a random selection. So in other words, I choose only the taxpayers which are called Irene and Pasquale, and I don't choose the other taxpayers, because that will really be infringing the equality. And from this perspective, I think that the techniques used for the analysis of big data are making a lot of progress, and artificial intelligence and blockchain is potentially improving the way in which tax authorities use and process information.
Right, true. The data mining, etc., is of course coming up, and in one country more than in the other. So should we help in that respect, or should we leave that to other people?
I think the point is that data mining and tax profiling raise issues of protection of data and at the same time right of privacy, but in principle they are not evil. They are better than random checks.
The International Conference for Taxpayer Rights in Minneapolis in 2019 in May was all about basically the protection of privacy in the world of big data. And you can go and see a video of that on the center's website. And you can
that is the center of?
The Center for Taxpayer Rights. So it's www.taxpayer-rights.org. And when you registered, there'll be a link to the center's website as well. And then you can just go on to the page that's for the international conference, and we have the videos. It's the 4th conference was in Minneapolis 2019. Stuart Gibson did write his letter, and he was following up about his comment, and he was following up about CIC Services, Inc., which is the Supreme Court case, and he was noting that he has argued and won many cases that made the same arguments about the Anti-Injunction Act advanced by the petitioner. And he asked what we proposed in our amicus brief, which the center was represented by the Harvard Tax Clinic at the Harvard Law School. And we were basically making the point that with collection of information, we believe that the Anti-Injunction Act should not apply, that there should be a right to come in when the tax agency is seeking a collection of information. We were not saying before the actual assessment or collection of tax that someone should not be in a position of having to have a penalty imposed on themselves just for the right of challenging whether that information collection was more burdensome. And if you don't have that right, that penalty could actually, and all you had was the ability to go to court after the tax was assessed, that may actually serve as a bar to you being able to avail yourselves of your right. And we gave an example in our brief, because we're definitely talking about low-income taxpayers. We gave an example in our brief of something that a test that the IRS did with respect to low-income taxpayers, where it was requiring in this test environment a lot of collection of information before the filing of a return even. And the IRS itself concluded that that collection of information was burdensome and would deter taxpayers from actually claiming a tax benefit that they were eligible for, and therefore did not proceed with that collection information request. And so that was an actual concrete example of what would happen if the IRS acted correctly, but there are plenty of times where it doesn't. We weren't saying throw the Anti-Injunction Act out. We were saying that it is ancient, and in tax world terms, from the 1800s, and that the tax world had definitely changed since 1867 or whenever, and that the law should sort of follow up, should be interpreted or at least, addressed in that way. So that's where we are.
Stuart's asked a follow-up question to that. He says, would that argument also apply for failing to file an information return, such as a Form 1099 or a Form W-4?
I think that in all of those instances, for example, there are regulations that cover, what's required to be formed, or some form of a notice that you would actually be able to get in on the actual systemic issue. And the problem with this, the way that this particular case was set up, it's not necessarily clear that you'd have that same way. There's no regulation on point that you could get in under the Administrative Procedure Act and, and say this was arbitrary and capricious. And Stuart is not buying that. So there you go. I wish we could unmute him and it's not deliberate. I don't know why he can't be unmuted. Anyone else?
Yes, on that point, there's a lovely case from the European Court of Human Rights from several years back on the right to silence, the right not to self-incriminate. I think it was a bunch of French lawyers who said they should not be required to submit tax returns, because if they made a mistake in their tax returns, they became liable for a penalty, and so they would be self-incriminating. The European Court in Strasbourg did not give that argument very much weight there. It's not. I don't want to minimize the issues raised in CIC. I think they're very important issues, and there is a read across from what you're looking at to the Berlioz case, because essentially in Berlioz, the taxpayer, the third party asked to supply information, said, I should have an opportunity to go to court to argue that this information is not required and cannot be lawfully obtained from me. And the answer that came back was, well, if you don't supply the information, you'll have a penalty and you'll have an opportunity to appeal against that. And that's putting the third party in a very difficult position, because they're saying, well, if you want to challenge this, refuse, face a penalty, and then you can appeal against the penalty. And at that point in time, you can go to court, which is really not an adequate remedy.
So we have a comment from Sudarshan.
Yes, good evening. I'm from India, so good evening and good morning to which part of the world. My question precisely to Professor Pistone, Pasquale. So he made a very interesting point, on the mandatory disclosure, and specifically he stressed upon that he gives a lot of weightage to rule of law. So this brings me to on the tax avoidance aspect, with especially gender anti-avoidance rule, which is now being codified as a legislation in quite a lot of countries, especially the Commonwealth countries or even developing countries. Now, from a taxpayer right perspective, the gender anti-avoidance rule, which by virtue of legislation being put in the domestic legislatures, one hampers, being an ex post analysis. One, it completely breaches rule of law to the extent that certainty is given a right, go by, legitimate expectation is given a go by, and also the element of retrospectivity. What I mean by retrospectivity is, I think Professor Baker can also relate, where coming from a common law, where we give a lot of precedence to binding precedents and stare decisis, where eventually goes to the court. So it's undisguised legislation. And again, going back to retrospectivity. So what is the erudite panel's view on the GAR principles vis-a-vis to taxpayer rights? Thank you.
Yeah, thanks to Darshan for your question. GARs exist throughout the world, and I don't think that GARs as such are a problem. The problem is the way that tax authorities apply GARs and the way that the judicial tolerates some improper exercise or use of the GARs. Now, a GAR doesn't deprive tax authorities of the obligation to give evidence of the so-called recharacterization of something that may constitute tax avoidance. So I see that the crux of the problem is there. GARs as such do not necessarily create legal uncertainty. Of course, there are people who are saying that when tax authorities have no better option, they go for using the GAR and that creates litigation and all the other. The way that I have seen that GARs are being used in some countries of the world, and of course, in particular where the judiciary tolerates, let's say, low standards of evidence, that is potentially undermining the rule of law. That's my point of view, Sudarshan.
Okay.
Perhaps I'll add a word or two about certainty and particularly about retrospective legislation, this is an issue where there's also focus coming out, for example, from the OECD and the G20 on the need for legal certainty. Legal certainty is particularly important in the tax realm. Taxpayers take decisions, both individuals and corporates, on the basis of the anticipated tax outcomes. And if the outcome is not what was expected because of the application, for example, of a GAR or retrospective tax charge, that interferes with legitimate expectation. It has an economic cost. It has an economic cost not only in that particular transaction, but also in the future, because taxpayers will have to factor in the possibility that they may have to contest a retrospective tax charge into their investment decision, for example, or the possibility that they may not get a particular tax benefit that they expected to receive. We perhaps, I mean, this is an area where it would be interesting to develop further work through the Observatory and how one obtains that element of certainty. In the case of a GAR, for example, it is not unusual for countries to have a GAR panel that provides guidance on the sort of transactions that may or may not be ones that would be subject to a GAR. I ought to know this answer and I can't, but I can't remember whether there's a GAR panel in India for the newly introduced GAR. I don't think there is, and I think there was some discussion about whether or not there should be a GAR panel. There is, for example, a GAR panel in the UK, and they've issued guidance on how they think the GAR should be applied. One of the slightly disappointing things about the OECD G20 approach is that they've focused on, if you like, ex post facto certainty, the ability to have disputes resolved by arbitration or by litigation. That's not what most taxpayers want. They don't want to find themselves caught in litigation for 5 or 10 years subsequently. They'd like to have clarity and certainty up front. Now, I noticed that I think it's Miss Tiega, Giovanna Tiega, who would like to intervene on that. So, Giovanna, perhaps you should, you're now muted, but if you'd like to unmute, perhaps you could come in.
Hi everybody. First of all, just a few minutes. I really like to thank you for your great efforts and keeping our community linked even in this very hard period. So I really thank you, Nina, Pasquale, and Philip, for your great efforts. And I'm also a national reporter for the Observatory of Protection of Human Rights, Taxpayer Rights. So I like just to point out my experience in this last years. This year we had a great change. So for each people included in the team, for example, the Italian or even other country teams, we need to focus on the same report, so the same file. That was different from last year's when we had different files to file. And but this was really interesting, and I want to share with you that this shift was really interesting for us to work. I mean, for Italian team to work together. We were from different, we were from the academics and some professionals and auditors. And that was really interesting for us to have the time to share information before filling the final report. So I really want to underline that the shift At the beginning, it was a little bit hard to manage, but then we really had the time to discuss and to overcome to a unique file. And this is really, thank you for the interdisciplinary approach that you are supporting for this project. The topic I'd like to underline that could be interesting, I think, for our text chat or even for the report, could be connected with what many jurisdictions are living. I'm talking about the decentralization of powers that many centralistic jurisdictions are now living. And I'm talking about Italy, but that is in common even with Canada or even with South Africa. So self-local governments or the devolution, the British area. So I'm talking about the local governments and the connection with the role of taxpayers as citizens that has to have the chance to say what he thinks. So I'm talking about participatory democracy. And as we are living many local public debates here in Italy, connected with the relationship between state and regions, I was thinking to share this issue because I think that, for example, the report could even give some more room, more space to the topic even of local tax advocates, like we have in Italy, and not just the national one. So I think we need to a little bit manage the process, the ongoing process that is connected with the devolution of powers between the central government to the local governments. I think this is something that could be interesting even from a taxpayer rights point of view.
Right.
Thank you.
Thanks very much, Joanna. If I can, Nina, I would like to take the opportunity also to thank Carlos Wefe, who's by our side at the Observatory in helping us to manage the Observatory, and he's, as Philip said, in the team. So, the improvements are also owed to all the time that Carlos is devoting to that.
Well, you all have been a great group. I don't want to push this too far, too long, but I do want to remind everyone that although we aren't having, an international conference on taxpayer rights this year, it was supposed to be September 29th through 30th in South Africa in the University of Pretoria. We're going to have two next year. One will be in May in Athens. On May, let me get the exact date, 27th and 28th. And then we will have the South Africa one in October of 2021 on October 6th through 7th. And we're also going to be holding a workshop the day before the conference, a half-day workshop on low-income taxpayer clinics and low-income taxpayer issues, so that because we are seeing the low-income taxpayer clinic movement kind of go international now. And so people that are interested in that movement or maybe starting it in their own countries can come for the half-day session right before. And if we are still in the midst of a pandemic, then we will do this virtually. We will not skip another year of conferences. There's just too much important stuff. The theme of the May conference is going to be about auditing and best practices for auditing, certainly tax and also taxpayers' access to information. And so it sort of carries along some of the conversation that we've had here today. And then, of course, we'll be having the agenda posted fairly shortly for the Athens one. We already have the agenda and the speakers for the South Africa one because it was supposed to happen in a month. And that's up on our website. And that theme is taxpayer rights and human rights as human rights. So with that, I'm going to end this. We will be posting the recording onto the website too. And I want to thank Pasquale and Philip. They've been, as I expected, fabulous first guests for our first tax chat. and we'll see you on the next one. Thank you all. Bye.
My pleasure. Bye. Thanks, Nina.
Yes,
Bye.
thank you. Bye-bye.
Bye.